Good morning, sir. Are you Joseph Curtis Jr.? Speak up, please.
Yes, ma'am.
And this is cause number 25 DCCR 1758. Mr. Curtis is charged with continuous sexual abuse of a child. And what is the announcement?
We would like to hold and not ready at this time. We have some mitigation we would like to get, and we haven't been able to speak with Ms. French.
Judge, I know that Mr. Johnson had reached out to Pam in after the last setting, and they were working on getting some information to her that I think is mitigation evidence. So I don't see a problem if it's all right with the board.
So this has been, it looks like Mr. Johnson substituted in December of 2025. I'm going to reset it one more time. That will be the final reset.
Yes, ma'am.
So whatever needs to get to Ms. French needs to get there quickly, so that she can take a look at it. And if that changes anything with regard to an offer, y'all can discuss it and have an announcement before the next court date.
Yes, ma'am.
All right, thank you.
Thank you.
You can go back with the bailiff.
And I'm It's stuff to go for you.
Hancock, and cause number 25 DCCR 0737. You're charged with the state jail felony offense of evading arrest or detention with previous convictions. And that's from April 22nd of 2025. The indictment alleges that you were previously convicted of evading arrest or detention August 9th of 2013. Some of these are with vehicles, which would make them different. Looks like we've got an evading with a vehicle, April 23rd of 2008, another evading with a vehicle, December 1st of 2008, and evading with previous convictions, June 12th of 2017, and evading also with previous convictions, June 12th of 2017, and evading with a motor vehicle, 2 cases on June 12th of 2017. Then the indictment further alleges that you were convicted of unlawful possession of a firearm by a felon, February 9th of 2009. Also possession of a controlled substance on that same day. And then after those were final, you were convicted of burglary of a habitation, June 12th of 2017. And what that means is that if you go to trial and you're found guilty and those prior convictions are true, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
So in clause number 25, DCCR 0738, you are charged with the 3rd-degree felony offense of continuous violence against the family, and that's from April 26th of 2025. And it alleges those same prior felony convictions, which in this case means that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison up to 99 years or life. Do you understand that as well? And then we've got cause numbers 25 DCCR 1233, which is another evading arrest or detention with previous convictions. And that's from August 5th of 2025. And then we've got 26 DCCR 1018, which is also an evading arrest or detention with previous convictions from March 18th of 2026. Those are both the same as that first one with those prior offense convictions that would make these second-degree felony offenses for punishment. You understand that? In all 4 of these cases, I have here on the tablet some plea bargain rejections that you've signed with Ms. Holmes, and it looks like the district attorney's office has made offers if you wanted to enter pleas of guilty. For the evading arrest or detention cases, it looks like it would be cause number 250737 and
I think
1018. There would be 12-year terms in prison with dismissals in the other evading and that continuous family assault case. You have every right to reject those offers and have all of your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are if you want to plead guilty.
Good.
You understand all of that.
Good.
I also want to make sure you understand that if you are found guilty on more than one of these, because they're different offense dates, there is the possibility that any sentence you receive on more than one could be stacked on top of each other. Do you understand that?
Yes.
And do you want to reject all of these, the offers on all of these cases and have them all set for trial? Mr. Nichols, is there any reason to believe that these offers would change or?
No, Your Honor.
So I do want to make sure you understand also, Mr. Hancock, that after today, I will not accept these plea agreements.
Yes, ma'am.
Once your case goes on the trial docket, it goes to trial, or you can enter a plea either open to the court or to some different.
Yes, ma'am.
You understand all that?
Yes, ma'am.
All right, then we'll get it set on the trial docket. Mr. Hancock, Ms. Holmes has been appointed to represent you at this point. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney.
Yes.
With your permission, I can release her and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So Ms. Holmes, I'll release you. We will appoint someone today. They should be out to see you at the jail very soon to begin preparation for trial.
Yes, ma'am.
All right, you can go back to the bailiff.
All right, Brenda, thank you.
All right. Are you Jonah Johnson?
Yes.
And Mr. Johnson, in cause number 25 DCCR 1775, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. And it looks like, has there been I guess I'm confused because the offers,
25 should be 20. It's 2 to 20.
it's a 2 to 20, and I don't see, is there going to be, or has there been, I don't see a notice of extraneous other convictions.
There is no, that's right, Judge. The max is 20, Judge.
So really, there's no offer. It's just to plead open or plead guilty to the max. Is that?
Judge, I was under the impression it was the first degree. Let me
don't you-
draw that offer.
Yeah.
The state's offer now is 15, Judge.
Okay, I'll hold it for a minute if y'all want to visit about that, or I can.
We've already talked about that.
Okay, so it doesn't matter if
It
it's,
doesn't matter.
okay, so with everybody's permission, I'll make that change here on this
Yes,
document.
Please, Judge. Thank you.
All right, so Mr. Johnson, what that means in your case is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes,
And I have the plea bargain rejection that you've signed with your attorneys that shows that the district attorney's office has made an offer of 15 years in the institutional division. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty.
yes,
You understand all of that?
yes.
And you want to reject that offer and have your case set for trial.
Yes.
All right, we'll get that done. Also, is there any reason to believe any evidence that you haven't either received or waiting on, or that would change this offer?
No, Judge.
And as far as you guys know, y'all asked for, everything's been received through the portal. Any media? Is there anything else that's outstanding that you know of,
Oh,
media wise?
No, Judge.
Okay. So y'all have requested and received the media if there is any? Perfect. Okay, so I just want to make sure you understand that after today, unless there's some new evidence that comes up that your attorneys or the district attorney does not know about, I will not accept this plea agreement. So after today, it goes on the trial docket, it'll go to trial, or there'll be a plea to something else, or if it's going to be this or lower, it would be because there's some new evidence. Does that make sense?
Yes.
All right, we'll get it set on the trial docket, and we'll let you guys will get a notice by email.
Judge, may I ask this court's permission? It's my first time trying
Sure.
to case for you.
Yes, sir.
Does this court set kind of like a docket control order where there might be a motion setting or? anything
So
like that?
what I do is I'll set a pretrial
Okay.
the week before the trial date.
Okay,
And typically our trial dockets are about 8-ish cases or so. And so on the pretrial, I will go through and see who's ready, who's not ready, whatever the case is. And then I'll order those for the next week. So you would know on the Tuesday prior to what number you are. If you're at the top or close to it and there's some pretrial issues that we need to deal with, we could do it on that day. Or if it's the number one case, we can do it on that Monday before jury selection, depending on what those pretrial motions are.
okay,
If there's something that is going to require more time, some type of suppression or some hearing that will take witnesses and more time, please get that filed quickly and I'll get it set well before that so that we can have that taken care of.
yes, ma'am.
Okay?
All right, thank you, Judge.
All right. Thank y'all.
May you be
Thank you.
excused.
Yes, sir. You go back with the bailiff.
And that's where this hearing leaves us, with two defendants making decisions that could completely change what happens next. One rejected a plea offer after the judge laid out the potential consequences, while another turned down a 15-year deal and chose to take his case toward trial. The courtroom made one thing clear. Once those offers are gone, there may be no easy way back. Now the question is, did they make the right call? Let us know what you think in the comments. And if you want more real courtroom breakdowns, make sure you subscribe and stay with us for the next case.